And I also, at this point, am going to admonish and rebuke you, Miss Love, to pay careful attention to how you ask questions.
And we are back, and we are back. Let's go ahead and get y'all to hit that like button, y'all. Today we're going to get into a really interesting video, continuing with our Mistrial Madness mini-series. Today we have Mounk Tounk on the stand, and you're going to see where things start to go wrong for Mounk Tounk. Remember, just a couple of days ago, the DA's office filed to have his probation revoked due to his testimony on the stand, and you're going to see some of that testimony today. Mounk Tounk is facing 30 years in prison as a result of what you're going to see. You're going to see a couple of mistrial motions, and you're going to see DA Love get rebuked. This was a really bad day for her in court. So without further ado, don't forget to like, comment, subscribe, and let's go.
Thank you. There you go.
Name Antonio Sledge, ANTONIOSLEDGE.
Good morning, Mr. Sledge, and you are perfectly situated, turning to the jury so that they can hear you. I'm going to stand over here so that you speak loud enough so that the last juror can hear you, okay?
Yes.
Thank you. Mr. Sledge, would you please tell the jury how old you are?
43 is the age.
Where did you grow up?
Atlanta, Georgia.
What part of the city did you grow up in?
Downtown Atlanta.
Did you also go to high school in Atlanta?
Yes.
And what high school did you attend?
Southside High School.
Did you finish?
No.
What grade did you finish? The last grade you completed?
Probably the 9th grade.
By 9th grade, could you read and write, though?
Yes.
All right. Now, do you have brothers and sisters?
Yes. Brothers.
How many?
3 living.
Where did you fall in line with your siblings? Oldest, youngest, middle?
Next to the youngest.
All right. Do you know of a person named Kenneth Copeland who answers to the name Woody?
Yes.
All right. You sort of frowned up your face. Why'd you do that?
No reason.
All right.
Come on now.
Do you know of a person named Jeffrey Williams who answers to the name Thug?
Yes.
What about a person named Shannon Stillwell or Shannon Jackson who answers to the name SB?
Yes.
Do you know a person named Diamante Kendrick who answers to the name Yak?
Yes.
Do you know a person named Demikion Garlington who answers to the name Lil D?
Yes.
Do you know a person named Quindarius Zachary who also answers to the name Lil D?
Yes.
How do you distinguish one Lil D from the other when you're just talking in regular conversation?
I call both of them D.
Okay. And if someone asks you which D, how do you respond?
D.
If you're talking about Quindarius Zachary?
D. Lil D.
Lil D. Do you know of a person named Rodelius Ryan?
No.
Okay. Do you know of a person named Marquavius Huey who goes by the name Quay?
No, I don't know him, but I've heard it around the way.
So you do know of him, or you?
I know of him.
Okay. What about Quamarvius Nichols? Do you know of a person named Quamarvius Nichols who answers to the name Quay as well?
Of him.
Do you know a person named Quantavius Greer who answers to the name Umfunk?
Yes.
Do you know of a Dolly Greer or a Max Greer?
Yes.
What about Dora Greer?
Yes.
All right. Do you know them to be Jeffrey Williams' sisters?
Yes.
Now tell the jury, if you will, how well you would say that you know Jeffrey Williams.
I've been knowing Jeffrey Williams since he was probably like 16.
How many years would that make it that you've known him?
what is 2024? Probably like it's been a minute. I can't really, off the top of my head, I don't really know.
If it was when he was 16, about how old were you when you first met him?
I was 20 something. I'm probably like 26. I'm about like 10 years older than Jeffrey.
Okay. Tell the jury, if you will, how well you know Shannon Stillwell or SB.
Well, I met Shannon around like 2014, 15, somewhere in that area.
When you say you met him around 2014 or 2015, what does that mean for you in terms of how well you know him?
I know we built a great relationship.
And was that from the start? From the time that you met him to now, you all have had a great relationship, or is that something different?
You said could you repeat yourself?
Yes, I can. Did you all have that great relationship that you just described for the jury from the moment that you all met, or did it develop over time?
From the time that we met.
Okay. And do you all still have that same great relationship?
Well, I haven't talked to Shannon because he's been incarcerated.
Okay, hold up. Your Honor, we would move to strike that last portion.
Yeah, please disregard that. All right. Give me just a second. Y'all didn't even get comfortable. I'll have to excuse y'all and see you back again in a few minutes.
Your Honor, may it please the court, on behalf of Mr. Stillwell, we are moving for a mistrial at this time. There's been a comment about my client, comment from witness Antonio Sledge about my client being incarcerated. It is prejudicial to my client, suggests a criminal history, it suggests a flight risk. It prejudices my client. Also, Your Honor, I would just note for the record that Mr. Sledge, my understanding is Mr. Sledge has been cooperative with the state, meaning he's made himself available. His attorney, Mr. Derek Wright, is here. Mr. Sledge has been here all morning. There's absolutely no reason that the state knew what questions they were going to ask. They knew that they were going to ask about the relationship with my client at this time. The duty is on the state to prepare their witnesses to not relay or testify to prejudicial material such as my client being incarcerated throughout this trial, and they failed to do so. So we're moving for a mistrial at this time.
Ms. Love.
Judge, the state objects to a mistrial. The question that I posed was not one I expected this witness to bring up Mr. Stillwell's incarceration. We'd ask simply for a limiting instruction for a few reasons. One, Mr. Shart indicated that his mistrial motion is based on the witness's reference to Mr. Stillwell's incarceration. There has been admitted as evidence that Mr. Stillwell got incarcerated at some point. We expect further testimony to come out with details about Mr. Stillwell's becoming incarcerated, and the witness's statement on the stand, even where I asked that it be struck, does not rise to the level of meriting or warranting a mistrial. And I can go outside and further caution him to not talk about anyone's incarceration.
Okay, and isn't Mr. Stillwell, in fact, charged in this indictment with possession of a firearm by a convicted felon?
He is.
Okay.
He is, Your Honor, and I don't think there's any dispute that my client was incarcerated at some point. He's been arrested for these charges. I mean, I think everyone would acknowledge that. But the fact that he's still incarcerated, and I just don't understand how the state could ask, how's your relationship with him on this date or today? And they wouldn't expect a witness who apparently wasn't prepped to say, oh, well, actually, I haven't been able to talk to him because he's incarcerated. That seems like a very
Well,
likely
that's not
answer.
exactly what happened.
Well, whatever the transcript shows, it seems like that was a very predictable answer to that question.
Okay. I mean, it sounded to me the way it came up. Please do further caution him, but it did not sound like that came up as a purposeful question to secure that kind of evidence before the jury. It was essentially like, how is your relationship with Mr. Stillwell? Well, he'd been incarcerated. That could be, and that's all that he ended up saying. That could have been at any point in the past. That did not indicate right now he is presently incarcerated. I'm going to deny the motion for mistrial. If you want any kind of instruction, let me know that. But given that evidence has already and is going to come out that at some point in Mr. Stillwell's past, he has been incarcerated, this really is nothing beyond what they're going to know anyway.
May I step outside?
You may. Do you want any sort of other instruction, curative instruction?
May I have a moment?
Sure.
Your Honor,
Yes.
I believe that you have already instructed the jury to disregard the last comment. So at this point, I don't want to bring more attention to it. I would, for the record, though, renew my motion for mistrial to preserve this issue and reserve it before the next questions.
All right. Understood.
Thank you.
Mr. Sledge, having looked at State's Exhibit 444 Yankee, the document that we referred to prior to lunch, is your memory clear on whether or not it says that you were at the McDonald's on Cleveland Avenue in section 7 of part 4 of this document?
You said it say I was at the McDonald's?
No. My question is showing you State's 444 Yankee.
Right.
Is that the document that you signed?
I
Hold on.
I don't remember when I signed.
Hold on.
I see my initial, but
Okay.
I don't.
Do you also see your signature?
I said I see my signature.
Okay. With the date?
Yes.
All right. Of December 28th, 2022?
Yes.
Okay. Now, on this document that you are looking at, can you read to yourself number 7?
Yes. I read it already.
Okay. Having read that document, are you able to tell the jury if the document that you put your signature on December 28th, 2022, said that you met at the McDonald's or something different?
It says something different.
Okay. And was that something different language that you asked the state to correct? In other words, does the document...
I don't, by me signing it say no, but I don't recall if I asked you to change it. I was asking you so much to change that never got changed, so I don't recall which ones I asked you to change.
All right. Since you said you were asking me so much to change that never got changed.
Overruled.
Are you able to tell the jury what all you asked to be changed that did not get changed?
I just told you I don't remember. The Lord, that been almost 2 years ago. I don't remember.
Okay.
Not that part. Not by signing.
Would looking at 444Y refresh your memory at all?
Yeah, you showing it to me, and I told you my signature on it. You showing me that, and I'm telling you that it's saying my signature on it, but I signed. I ain't saying I didn't sign. I'm not arguing with you or debating with you about that. I'm not saying I didn't sign. I just didn't remember what I was signing. I just was signing.
Thank you for that. My question is, are you able at all to remember what things you recall asking the state to change that it did not change?
No,
Objection asked and answered.
Well, can you rephrase that question? Because you've asked him the totality of it. Are you trying to ask him, is there anything that he remembers?
Yes.
Okay, try that.
Yes. All right. Thank you. Asking it in a better way. Is there anything you remember asking us to change that we just refused to change?
I can't remember exactly, but if you show me the paper, I probably can point out the ones that I wanted you to change that didn't get changed.
I'm going to show you states 444, and if you would not read anything, just tell me numbers.
I'm just pointing to you.
Okay. Go ahead.
Is this 444Y?
Yes, it is, Judge.
I know this one.
Your Honor,
Yes.
for the purposes of the record, I would just, I believe Mr. Sledge just identified one. If he could just say the numbers so we can follow, because we're not looking at the sheet along with him when he points.
Sure.
Number 8, number 9. I don't know if number 7 or not. Because I don't remember.
I'm sorry, what did you say about number 9?
I said number 7. I don't know. I know number 9 is one I asked you to change.
Did you say I don't know about number 7?
Yeah, I don't really remember about number 7, but I know what it's saying isn't true.
Number 7, you're saying is not true.
Yeah, I didn't hear that from that part. I heard it in the streets, not from a member. Do you understand what I'm saying now?
I hear your testimony, yes. Are those the only 2?
That's 3. Well, I said 7, I didn't really know. But 8 and 9, I most definitely remember asking you to change, and they never got changed.
Anything else?
No, not that I know of.
Now, when you say that you asked me to change 8 and 9, how did you make that request? Did you personally talk to me, or did you ask someone to tell me?
I was telling my lawyer those were not correct.
And he came back and, at your request, he asked the state, that's your understanding, to change those?
I don't know personally what went on between y'all. Wasn't there. I was in the back. Y'all was in the courtroom.
Now, at any time were you forced to put your initials on anything on this document that's labeled 444Y?
I was actually told you can initial, but you can get if you be called in, you can explain the truth, what you know and what you don't know.
Is it your test? So are you now testifying that your initials are placed beside numbers relating to statements that are false? Is that what your testimony is?
Yeah, cause I don't know that. That's why I'm saying it's false. There's no way that I can know that if I wasn't there or no one who you have charged told me. I was personally charged with that same thing you talking about. From the beginning, before any of these guys, except Shannon Stillwell, any one of the other guys, before they were charged with it, I never heard of that until May 9th when you put it on your indictment.
Okay. I'm going to show you that same document, 444Y, and ask you to look at section 5 of the document. And looking at it, is there a marking on the document? Does it refresh your memory as to whether you personally marked anything out on the document?
I see my initial by whatever it is.
Does it refresh your memory as to whether you scratched anything out and changed it?
I think y'all told me to scratch that. I didn't change it. You wrote that. I didn't
Okay.
write that. That's not my writing. That's my
Is
initial.
that your initial? Okay.
Yes.
Is the change that you referred to on section 5 of page 6, is that the only thing that you recall being changed at your request?
No.
What else do you recall being changed at your request?
Well, now, yes. I'm sorry. Y'all can scratch. No. Yes. I don't remember nothing else you changed at my request.
Would showing you any other documents refresh your memory?
No.
Okay. So number 3 on 444Y, which we were discussing before lunch. Can you explain to the jury how your participation in a drive-by shooting was intended to express support and loyalty for YSL?
I'm sorry, I didn't.
I mean, it has sort of been asked and answered in that he, sustained.
Tell us what happened in the drive-by shooting.
What you mean? Go into details what happened?
Yes, sir.
Well, I never, like, at the club, Garlington got jumped on. Which,
Mikion Garlington?
the Michigan Garlington, which didn't have anything to do with anyone else besides me and Garlington.
How do you know?
Huh? How did I know they had nothing to do with no one else?
Yes, and yes.
Because no one else was in the club with us, got their hands put on them.
So who was it that put hands on Garlington?
I don't know. It was a group of guys. I didn't see no faces, none of that.
So how are you able to tell the jury that it had nothing to do with anyone except you and Garlington when you can't say who put their hands on you?
Well, I can say what Garlington told me, but I can't tell you. Do I know it's personally was those guys? Because there was a lot of them, but I can tell you what Garlington told me.
Were those guys part of a gang?
Objection, Your Honor, calls for hearsay.
Well, I mean, it may or may not, to your personal knowledge.
Did you believe that those guys who put their hands on Garlington were a part of a gang? I asked him,
Staines. Rephrase your question.
to your knowledge, were the persons who put their hands on you, or on Garlington rather, excuse me, a part of a gang?
I don't know, because if they joined the game, I wasn't there when they joined the game.
If they joined a what now?
If they was part of a game,
When you're saying gang, are you saying, spell what you're saying?
G-A-N-G. You
Okay.
said game.
I did, thank you.
So if they was part of a game, whenever they joined, I didn't eyewitness. So I don't know if they was or was they false claiming or what. I don't know.
Okay. So forgive me for interrupting. Please tell the jury what led up to the drive-by shooting. What happened?
Well, they jumped on Garlington in the club. I assisted Garlington. And then it went farther with us fighting. And then I don't know what happened on the outside. I don't know what happened on the outside, but then me, Garlington, and Zachary, we went and we did what we did.
Okay. Were you standing next to Garlington when he first got jumped?
No, he was coming back towards me.
And you said you didn't see the face of who jumped him.
I never really seen it. Somebody told me that they was jumping on Garlington.
Who
And-
told you?
People in the club. I can't give you a name because I don't know their name.
So what did you do?
I assist Garlington.
How did you assist Garlington?
I helped get him off Garlington.
As you were helping getting them off of him, did you recognize anybody that you were helping to get off of
It
it?
was abroad. No. There was so many people.
Okay. You said earlier that you didn't know whether these people were actually a part of a gang or if they were false claiming.
Right.
Do you know what gang they claimed to be a part of, if any?
Maybe ask another foundational question first.
Are you aware of whether these people that you pulled off of Garlington claimed to be a member of any particular gang?
You said, did they claim to be part of a gang?
Correct.
Overruled.
Actually, I can't really say what gang they claim.
Without saying what gang, at the time that you pulled these guys off of Garlington, did you believe that they belonged to any particular gang?
Overruled.
No.
Are you familiar with a person by the name of Kelvin Watts, who answers to the names Kel and Shell Kel.
I know of him, but I don't know him. He wasn't there though that night. I know that much.
Does Shell Kel, to your knowledge, belong to a particular gang?
Well, I heard that he was part of a gang.
Are you aware of whether he claims to be a part of that gang via his postings or anything else?
Yeah, a lot of people claim to be some, they ain't.
Fair enough. What gang do you understand Shell Kel to be a part of?
What he claimed, 9 Deuce or something like that?
9 Deuce?
Yes.
Is that also If Gang or Inglewood Family?
From my understanding.
That's a yes?
Yes, from my understanding.
Okay.
I don't.
And is that gang, to your understanding, a blood gang? If he knows, Your Honor, I'm asking to his understanding, does he understand that gang to be a blood set?
Overruled.
Yes,
You
I
may-
heard, but I don't know for sure. I heard.
Did you consider that gang a rival gang?
Please use your mic. Sorry.
A rival gang? No.
Did you state on December 28th, 2022, that you threatened to harm a person named Kel because of that person's association with a rival gang?
Yeah, but at the time I didn't know. At the time that the threat was made, I didn't know he was If gang.
When did you learn he was If Gang?
Ooh. I know it was after that video.
Okay. Now we're talking about a video. What video are you referring to?
The video of me and Quindarius. But it wasn't about no gang situation.
What did you do in the video?
I told him if he was looking for me, I had something for someone who was looking for me, who was not my friend.
And forgive me, you told him that if he was looking for you, what was that last part?
I had anything for anybody who's looking for me that's not my friend. He has no reason looking for me if he's not my friend.
Okay. And what did you have for him?
Whatever to do to protect myself.
Who else was in the video with you?
Quindarius Zachary.
Is he the only person?
That's the only person I remember.
I'm going to show you what we have marked as State's Exhibit 441Y, which has also been provided to counsel for the defendants with the court's permission. Madam Clerk.
You may.
Are you able to see the video on the screen?
Yes.
Okay. And when do you recall that video being made?
I can't recall. I just know it was in. I can't recall. I know it was in. I think it was in 2015 or 2014. I don't recall.
What did you do with that video once it was made?
They posted on social media.
Who is they?
I want to say Zachary posted. Or did I post it? I don't recall who posted, but
It was either you or Zachary.
yeah.
What are you saying in the video?
I just told you what I said.
Is State's Exhibit 441 Yankee, is that a fair and accurate depiction of the video that you?
The video you just showed me?
Yes.
Yes.
Your Honor, the state tenders 441 Yankee as evidence.
Admitted.
And with the court's permission, while we are pulling that up, I'll go ahead and ask you additional questions.
That's fine.
Thanks. Do you have anything? Do you have anything in your hands in the video?
Yes.
What?
A gun.
And does Zachary have anything in his hands in the video?
Got 2 guns in his hand.
What was the purpose of posting that video on social media?
We were really being silly, man.
Okay. And when you say you're being silly, what do you mean?
It was childish.
Did you intend for people to see it?
They posted on Instagram, so of course people were gonna see it.
Understood.
We posted it for him to see it.
Would you please continue? Hang on one second. If it's ready to play, we can play it. And we are now publishing State's Exhibit 441 Yankee after we hide the floating toolbar.
Little strip ass nigga.
We ain't really going back and forth with no nigga.
You little bitch ass nigga.
I know
wanna
we
see
hit.
me? I'm everywhere. Yeah, fuck you nigga, Cal. Whoever else, nigga. Well, nigga. Pop, pop, pop. Nigga. Whoa.
They said I ain't really going back.
Is that the video you're referring to?
Yes.
All right. Now, would you continue telling the jury what led to the drive-by shooting following Demekion Garlington getting jumped on at the club?
What led to it?
Yes, continue telling us what happened.
We left the club and we went over. Well, no, we didn't leave the club. I left the club and then Garlington called me to come back to get him because I left him at the club.
Did Garlington ride with you to the club?
No,
Do you know who Garlington went to the club with?
no, he was calling me all that day to ride me to the club, and I don't like people to ride to the club. I mean, I go to the club by myself. I might meet them there, but I always ride by myself.
Who all participated in the fight when Garlington got jumped?
Just me and Garlington. No one else was in the club with us.
All right. And so after, how did the fight end?
Security guard broke it up.
After the security guard broke it up, what did you do?
I stayed in the club. They put Garlington out the club.
And then what happened?
I was in the inside looking for Garlington's phone with security guard, and I guess security guard found the phone and he took it outside. And then eventually I got the females that I was with and we went outside.
And then what happened?
I pulled off. Garnington was talking, saying something, and I got in my car and pulled off. And by the time I got to the spreadway, Garnington called me back to come pick him up because he didn't have a ride.
What club were you all at?
Club Crucial.
And what day of the week was that?
It wasn't a Monday, so it had to be like a Saturday or something like that, if I am mistaken.
What did Garlington call you back for? Just to get a ride?
Yeah, at first just to get a ride, yes.
What then did it later turn into?
It later turned into a shoe.
Tell the jury how that happened.
I guess Garnington didn't want to let it go, and I was riding with Garnington. Which I probably wouldn't have let it go neither, because another grown man ain't got no business putting his hand on no grown man.
So fill in the blanks and tell us, from the time that you went to pick up Garlington, what happened that led you to participate in a drive-by shooting?
I don't remember. I can't remember all the details that happened that night, but I just know it was a drive-by shoot. Well, it wasn't a drive-by shoot.
What
It
was
was a shooting. Cause I didn't see nobody shoot. If that makes sense.
Please explain.
I never seen them shoot. Cause I dropped them off and I kept going.
And then what happened?
I guess they did the shooting.
Did you drop them off at any one particular spot?
I don't know the name of the street.
Understood, but did you drop them off at any one particular spot?
I don't remember.
Did you take them to more than one spot? Can you refresh my memory if you can? Let me try this another way. Were you asked to take Demekion Garlington or anyone else in the car with you to more than one spot?
No, I remember taking Zachary, to his cousin's house somewhere.
So what happened at the spot that you said you dropped them off at?
I don't really remember, Ms. Love, but I know I pleaded guilty to it. I don't remember, but I know I pleaded guilty to it. I don't remember all the details, but I pleaded guilty to it.
Mr. Sledge, is a drive-by shooting or shooting something that stands out in your mind, or is it something that's just commonplace for you?
Could you repeat it?
Is a drive-by shooting something that stands out in your mind, or is it something that is just commonplace for you?
Could you break it down? Because I don't understand what you're saying. You saying, is it in my mind or is it just something I do?
Is it something that is worthy of remembering for you? A drive-by shooting?
No.
It's not something that's worthy of remembering?
No.
Okay. So it's not a big deal for you?
Not for me.
Was more than one house shot up after Demekion was jumped at the club?
Probably I wasn't there. I probably was, I'm saying, but I didn't take him to more than one place.
Do you recall going to Adele Drive?
Where is that located?
Off of Martin Luther King in, I'll rephrase. Do you recall going to an area off of Martin Luther King called Adele Drive?
Yeah, I think that was Wolf.
Do you recall going to a location on Drew Drive?
No, they lied.
Night.
No, I don't recall going to drive, but I know it was all in my plea agreement. I just thought it was best in my interest, so I pleaded guilty to it.
Did you ever talk about that shooting with Quindarius Zachary or Demikion Garlington?
What you mean that night?
At any time?
No, we didn't really talk about it.
Okay. When I asked you whether you threatened to harm Kelvin Watts because he was affiliated with a rival gang, did you say rather, at the time you made the threat, you did not know he was IF gang. Did you say that?
Yes.
Why did you make an assertion about IF gang when I asked you about a rival gang?
Because it ain't, Ms. Love, it ain't like I don't know what y'all trying to put together. I know what you saying and I know what the state's saying, but that don't mean it got to be true.
Mr. Sledge, do you understand that I'm just asking you questions so that you can speak to the jury?
And I answered it to the jury like.
You didn't answer the question. My only question to you was, why is it that when I asked you whether you threatened to harm Shell Kell because he was affiliated with a rival gang, you responded, at the time I made the threat, I didn't know he was IF gang.
I said I didn't know he was 9 Deuce.
Object. That's a misstatement of the evidence.
Sustained. The witness corrected it.
Thank you. Why did you say that at the time you made the threat, you didn't know he was a member of that gang?
Because the state, this is what the state painted a picture that YSL, I'm answering the question if you're going to let me answer. The way I know the answer. If you're not going to let me answer,
ahead,
then.
Mr. Sledge, go ahead.
Because the state is painting a picture that YSL and 9 Do is the rival gang. So I know you saying it don't take a rocket science to figure that out.
Has anyone instructed you to come in here and talk about what picture the state is trying to paint?
No.
Has anyone instructed you just to be honest?
I'm being honest. You might think I'm not, but I'm telling you I'm being honest.
Okay.
I'm being honest as I can.
So irrespective of the picture that the state, in your opinion, is trying to paint, why did you bring up the name of that particular gang when I asked you about a rival gang?
It's also
No, it hasn't overruled.
It's also a misstatement, Your Honor. Miss Love brought up IF gang.
Right.
Correct. Go ahead, Ms. Lowe.
All right. How did Quindarius Zachary get in the picture
What you mean?
as it relates to this drive-by shooting on April the 28th? How did Quindarius Zachary get in the picture?
I don't know if Garlington called him. I think Garlington called him and told him he had got jumped on before I even made it back to Garlington.
And so how did Quindarius Zachary get with you all?
What you mean? We went and got him.
Okay. So after you picked up Garlington from Crucial, you all then drove somewhere else and picked up Zachary?
Right.
Where did you all pick him up from?
I don't remember.
Who was it that told you which house or houses to go to?
I don't know who told Garlington.
No, who told you you were driving, right?
Yeah. Garlington told me how to get there.
Okay.
Lord, they already have told you all this stuff. Well, you're right. You got to tell it to the jury. I'm sorry.
And you understand, I can't tell the jury.
Right. You're right.
Would you please tell the jury whether at the time you took Garlington to that house, you knew or believed that it was the home of a rival gang member?
Yeah, that's what I believe.
Okay. Did you see the guns did anyone have guns in the car at the time that you took Garlington to that house of the rival gang member?
We had guns. We roll with guns every day. Not one day, every day.
When you say we, who are you talking about?
Me, Garlington, and Zachary then.
Okay.
Whenever we was together.
At the time that you were together, were Garlington and Zachary also members of YSL? Apologies.
Well, everybody probably assumed they was YSL, but I can't. Well, I heard them say YSL, put it like that. So I can't really actually say.
Was it your understanding at the time that you took them to that home of the rival gang member that both Garlington and Zachary were YSL?
I believe so, yeah.
How did Nine Deuce become a rival gang?
I have no idea.
Who was it a rival to?
You said, the state say YSL.
You're the only one that can give testimony. So who was it a rival to with your understanding?
Well, from my understanding, it wasn't a rival with everyone who claimed YSL. There probably was certain people, not everyone.
Okay. So who was it a rival to? Who was this gang a rival to?
Me, Garlington, and Zachary at the time.
Okay. No one else?
Not that I know of.
Did you say on December 28th, 2022, that you and your fellow YSL associates committed the drive-by shooting on behalf of YSL and to increase the notoriety, reputation, and fear of YSL?
Again, that was some you stated and some I initiated. I'm more definitely initiated that.
Earlier, go ahead.
Because none of the stuff on the paper, I never approved none of it. I signed, but if you would have came to me and asked me that before, I would have told you it wasn't true.
Earlier, when we were talking about changes that you asked to be made, do you remember having an opportunity to look at the document that is labeled 444 Yankee?
To be honest with you, I didn't look at the whole document.
Okay. So if I give it back to you, will you look at each of the factual acknowledgments contained on the document?
I already told you, Ms. Love, I initiated on it.
That's not what I'm asking.
Yeah, I can.
Do you need an opportunity to look back?
I can look back on it.
When you've had a chance to read each of them, would you just look up? Could you read each of the items under that section, please?
You just read them, Ms. Love. I am.
Do you not want to read them?
No, I don't want to read.
Why don't you want to read them?
Because I don't want to read. I just answer to you.
Okay.
I don't want to read.
Having had the opportunity to look at the factual acknowledgments, what other factual acknowledgments besides the one you listed as 8 and 9 are you now saying aren't true?
Your Honor,
Yes.
that is a misstatement of the evidence. He said that 7 is not true as well.
Yep. Sustained.
I'll rephrase. Earlier, did I ask you to identify which portions of the factual acknowledgement that you asked the state to change?
And I told you 8, 9, and I couldn't remember if I asked you to change some, but I know some is false.
Okay.
That's what I told you.
If you understood that you could ask me to change 8 and 9, would you explain why you did not ask me to change any other ones?
I can't say, my Lord.
Did the state force you to sign this document?
I was forced. I feel like I was forced myself.
I'm sorry, what did you say?
I feel like I was forced myself because I was going through something.
Explain what you're saying.
I was going through something with my mother being sick. I needed to get home to my mother. And if I went to trial, I couldn't afford Mr. Wright to go to trial.
Could you afford to ask Mr. Wright to make any further corrections to the document?
That specific day, Ms. Love, I was just trying to get home to my sick mother.
Did you swear under oath that each of these statements that you initialed were true?
Maybe. I don't even remember. I can't say. If that what it say, yeah.
Did you lie under oath?
No, I didn't lie.
Well, explain to the jury how they should reconcile those two statements.
I really can't explain it to you, Ms. Love.
Did you sign a statement? Did you make a statement
I didn't. Go ahead.
That you have read and carefully reviewed the agreement that you were entering with the state, that you have reviewed and corrected where necessary for accuracy each statement contained in defendant's factual acknowledgments, and that you acknowledge the truth and accuracy of each and every statement listed therein, that you fully understand the agreement and have had an opportunity to discuss this agreement and each of its provisions with your attorney, Mr. Derek Wright. No promises other than those contained in the agreement have been made to you in furtherance of the agreement, and you freely, knowingly, and voluntarily enter into the agreement without force, threat, or coercion. Did you make that statement on December 28th, 2022?
I think so.
Okay. Was that statement true or false at the time that you made it?
I don't know, Ms. Love.
Why do you say you don't know?
I really don't. I just told you my intention was.
I understand. And my condolences for what you had to go through. But the jury needs to know whether that statement that you made was true or false. Would you please tell them?
I guess it was true if I made it, Ms. Lord.
Why did you pause so long before answering?
I don't know.
Now, you were talking about having pled guilty to charges related to the drive-by shooting or to the shooting on April 28th, 2015.
I pleaded guilty.
Excuse me, Judge. At this time, can we get the instruction, please? That's the first question directly from the state.
Yes. Ms. Levis?
Yes.
Okay. All right. Ladies and gentlemen, you are about to hear evidence that a co-defendant in this case has pled guilty to some of the charges in this indictment. I caution you that this co-defendant's guilty plea conviction itself is only admitted for a limited purpose. That guilty plea is an admission by this witness only that he committed the criminal acts to which he pled. You are not to consider the co-defendant witness's guilty plea as evidence that any other defendant is guilty of committing any of the criminal acts alleged against them in this indictment. Each defendant is entitled to have the issue of his guilt determined solely on the basis of the evidence against him and not on whether another person has been convicted of the same charges with which the defendant is accused. If you find that the co-defendant witness provided testimony on the stand that is inconsistent with his guilty plea admissions, you may consider the witness's prior inconsistent statement, that is, his guilty plea admissions, including to the allegations in the charges to which he pled guilty, as substantive evidence, which you may consider against any defendant currently on trial for whatever bearing it may have on the issues on trial.
Thank you, Your Honor. So, Mr. Sledge, you mentioned pleading guilty to charges related to the April the 28th, 2015 shootings that you were just talking to the jury about. Do you recall that?
Yes.
All right. And when you pled guilty, did you do so in 2022 or did you do so in 2015 or 2017?
Obviously, I pleaded guilty 2017.
Thank you for that. So, at the time that you pled guilty in 2017 to the charges related to the April 28th, 2015 shooting after Demekion Garlington was jumped, was there a factual basis given for that plea? Do you understand the question?
No, what you mean?
Okay.
I don't.
First, let me ask you, when you pled guilty in 2017, did you have an attorney?
Yes.
And is the attorney that you had then the same one that you have now?
Right.
And did you trust him then the way that you trust him now?
Right.
Right. And at the time you pled guilty, did the prosecutor tell the court that the evidence would show that on April 28, 2015, Mr. Garlington and Mr. Sledge were at a club called Club Crucial on Donnelly Hollowell Parkway earlier in the evening when members of and preface this by saying Mr. Garlington, Mr. Sledge, and Mr. Zachary at this time were members of a gang called YSL, or Young Slime Life, that at some point had been affiliated with the Blood Criminal Street Gang. There had been a falling out carrying from the fall of 2014 into 2015. This, for lack of a better term, gang war was going on at this time. Mr. Garlington was jumped at the club by members of a rival gang, Aaron Mills, Dominic Carter, and others that are members of a gang which is a subset of If Gang, or Inglewood Family Bloods, which is a gang that the dispute was going on with at that time, when Mr. Garlington was jumped and assaulted at the club. A decision was made by Mr. Sledge. They called Mr. Zachary, the co-defendant, to retaliate in some way. The evidence will show that Mr. Sledge drove the vehicle. Mr. Garlington and Mr. Zachary were inside with weapons, and they first drove by Adele Avenue, 1428 Adele Avenue in Atlanta, Georgia. And that location at the time is the home of Darren Mills and his mother, and at least one of his sisters and one of his cousins, and is an address that Darren Mills actually used and stayed at. He was one of the individuals that had assaulted Mr. Garlington earlier at the club. Mr. Sledge drove by and they shot at the house. There were not individuals outside of the house, but the house was shot. During the shooting of that house, Miss Denise Bell, who is the aunt of Darren Mills, while she was in her bed, sustained a gunshot to her buttocks and had to go to the hospital and had to have surgery. She was shot. The house was shot up, and there were other individuals there at the time, including Cecilia Davis and Diamond Mills. Diamond Mills being Darren Mills' sister. Also, the car belonged to Cecilia Davis, which was in front of the house and received damage. The evidence is that Mr. Sledge was the driver of the car. After that, Mr. Sledge drove over to 1903 Drew Drive, Northwest, an apartment there was at the time being used by Philip Collins, who is Darren Mills' brother, and also present at the club and participated in the assault. In shooting at what they believed to be Philip Collins' apartment, they damaged apartments 1122 and 1120. Natasha Battle's apartment, which was 1120, her patio doors, windows, and couch were damaged from the gunfire. Ms. Troutman's apartment was 1122, and that was the other apartment that was damaged. Through investigations, detectives got a lead that Mr. Garlington and Mr. Zachary were involved, and they conducted interviews.
Yes, sir.
I can pause there.
Okay.
Was that factual basis? Were those words read to the court by the prosecutor at the time you entered a guilty plea in 2017?
I don't remember, was it read by the prosecutor, because I took a blind plea. And I think the judge read off the evidence. I don't recall what it was, though.
Okay. Do you recall hearing those words read by somebody in court as the reason or the factual basis for the charges that were being brought?
If I could explain, I pleaded guilty because I felt like it was in my best interest. You had two co-defendants. Some of what they said was true, and some they said wasn't true. But I did plead guilty because I felt like it was in my best interest.
Were you given an opportunity to say anything at the time that you entered that plea? Were you given an opportunity to make any statements?
No, not that I remember.
Do you recall the judge, after those statements were read, asking you, is there anything you'd like to say before sentencing?
Oh,
Do you recall that happening?
Yes, I recall him asking me that.
Do you recall telling the judge, no, sir?
I remember telling him, thank him for the plea that he allowed. I remember that. I remember me telling him, thank him for the plea that he accepted on the non-negotiable plea, the blind plea or whatever it was.
Would you explain to the jury what your understanding of a blind plea is?
A blind plea that I understood that you leave the evidence up to the judge and the judge determine on the sentence.
At any time, did you tell the judge, I'm not admitting this, I'm just doing this because it's in my best interest?
Well, I didn't tell the judge that. I told my attorney that. When my attorney asked me, like, when he came to me with the plea deal, and I told him, I said, why take the plea? Because it's best in my interest. You got two guys against one.
Hold on. At the time that you...
No, I didn't tell it to the judge.
That wasn't the question.
Oh.
At the time that you pled guilty, did you know what sentence the judge was going to give to you?
No.
Okay.
Not like no, I just knew it was
Did the judge, was it explained to you that you could receive up to the maximum sentence on each charge?
not if I understand. I think a deal was already worked out, if I ain't mistaken. That what made me take it. I think it was already worked out between my attorney and the state.
Do you understand the difference between a negotiated plea and a blind plea?
No.
Okay. Have you done anything besides a blind plea in front of a judge before?
Yes, I think I have, yes.
And when you pled guilty on December 28th, 2022, was that a blind plea or something else?
I think it was just a plea. It wasn't a blind plea, though, if I'm not mistaken.
For a regular plea, what do you understand to be the terms? In other words, do you know your sentence before you plead guilty with a regular plea?
I don't know, because before the blind plea, I knew my plea.
Why did you then distinguish for the jury that it was a blind plea?
It was, but I already knew the sentence. My lawyer had already aware to me that they was offering the same thing. They was offering the co-defendants what they had pleaded guilty before me.
Okay.
So when I pleaded guilty, my lawyer aware me that they was offering the same plea deal that they gave them. But in my plea deal, I told my attorney that, like, I didn't want the probation. I just take the straight prison sentence.
Okay. Yes, sir. All right. Outside the presence of the jury? Okay. Yes? Yes. Okay. I'm going to excuse y'all to the jury room.
Your Honor, will the witness be excused?
Yes.
And Your Honor, may I first grab it?
To do what? Sure. Yes, sir.
Thank you, Your Honor. Your Honor, I have a motion for a mistrial. The evidence has just come out that two co-defendants who, to my knowledge, at least one of them is not testifying and has entered a guilty plea. That is a confrontation clause violation to Mr. Williams and the other people on trial. In addition, Your Honor gave an instruction with the last line, and I know it was objected to previously, but I want to stress this, that if it's a prior inconsistent statement, it can be used against Mr. Williams and the other people. That was premature, because I don't believe there's anything inconsistent as of now. And then the third reason I'm moving for a mistrial in the aggregate, Your Honor, is that the prosecutor uses and reads the statement of the then prosecutor, I believe it was the Honorable Mr. Bailey, who entered this plea and gave a factual basis. But she did not make it clear that the Honorable Derek Wright said on page 12 of this transcript to the same court that Mr. Sledge is tendering the plea under Alford, which is ALFORD.
Yeah, I'm seeing the same thing. And honestly, I thought that we were going to be dealing with the guilty plea that he took in this case. And yeah, that's problematic that this 2015 case is an Alford plea. And so I don't think that any of what I said with regard to admissions is actually true, even against this. I mean, he's saying he pled under Alford, and I don't know why the disposition sheet doesn't say that, but it is very clear that this is an Alford plea in this 2015 case. So Mr. Wright wants to share something.
Yeah,
Yes, sir.
I was just waiting for the appropriate time that I was going to point out that it was in fact an Alford plea. So I thought her cross-examination was not appropriate.
Well, y'all, I mean, maybe that, yeah.
It was something other than an Alford. So
Well, maybe don't wait so long next time. But I mean, I'm definitely going to, Ms. Lev, do you want to be heard?
Yes, please.
All right, go ahead.
One, we'd ask that the court deny the motion for mistrial. Number two, we would ask, as it relates to the assertion that no inconsistent statement was made, in the factual acknowledgments.
Okay, no, see, that's the deal with an Alford plea, is you are not acknowledging that the facts are true like you would in a regular guilty plea. You're saying, I think that the state has enough evidence that a jury could be convinced beyond a reasonable doubt that these facts are true. But you're not acknowledging on your own, yes, these are true.
Your Honor, when I spoke of the factual acknowledgments, I meant 444Y.
Well, that's what I thought you meant.
Within 444Y, we referenced this particular
All right, let's
section.
Maybe if you can point me specifically, let me pull that one up.
Page.
Which number? Go ahead.
Number 3 on page 3 of 7, under defendant's factual. I'm sorry, not number 3, number 4, on defendant's factual acknowledgments, on or about April 28, 2015, as reflected in Fulton County Indictment 15 SC 138994, defendant and fellow YSL associates Demekion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video referenced in Part 3 of this section, targeting family members of a rival gang. Number 5, defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL.
Okay, and so those factual assertions, what I read as the limiting instruction, would be true for? But the factual basis that you just read out from the 2015 one, that's a whole lot more than what's in numbers 4 and 5.
Your Honor, in number 6, defendant admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in the drive-by shooting referenced in section 3, 4, and 5 above.
Okay.
And so if I'll, of course, comply with whatever appropriate instruction that the court deems necessary to give as it relates to the conviction of this witness for 15 SC 138994. But given the factual acknowledgments that were made as it relates to 22 SC 183572, and the fact that this witness did not assert, even though the plea was given in his best interest, he was allowed an opportunity to say what he said here, and he did not say it.
No. When a defendant has an attorney who is saying, we are pleading this because we believe it to be in his best interest, the defendant does not then independently need to say, yeah, by the way, Judge, here's what Alfred means.
Understood.
So no. Are you going to tender for admission any part of 444Y?
Yes, the state intended to tender 444Y.
In its entirety?
Yes,
Okay.
I did.
Any objection to that being tendered or admitted in its entirety?
And if there is an objection to it, then
All right,
we would just...
let's find that out.
Okay.
Yes, I object at this point to the entirety of the document unless the state can give reasons for which parts of the document are admissible at this time. And if they're not tendering yet, I understand that. But I can't get around how we got here. I'm trying to follow this factual basis, and I realize I asked Ms. Renard, R-E-N-A-R-D, for this, and we're in a different case.
Yeah, we are. So, we've been talking about these 2015 crimes, and we've been talking about, what's been going on in this 22 indictment. So, I guess that's how it came about. But I wish we'd been a little more specific about it all beforehand, because, I noticed this morning that this was an Alfred plea. And I would have had issues with when you started reading out the factual basis. I'm thinking, well, is this some other case that I don't know about that's not the 2015 case and not the 22 case? Because we should have been reading the factual basis from the 2015 case.
Your Honor, the 2015 case, I understand what the court is saying. The 2015 case is one of the overt acts that we allege in the indictment. And as it relates to the defendant's conviction for the 2015 case, we believe that it would be appropriate is an appropriate matter for cross-examination, and it appropriately falls under the portion of the court's instruction where it tells the jury that the conviction itself is not to be considered as evidence. And to the extent that Mr. Sledge is asserting that he didn't do it, that he dropped someone off, that is what he asserted, by the way. He said that he was not present. He dropped him off, and it was only one house.
Well, we all know how party to a crime works. So, yeah, he said, I didn't shoot. but he
said
did
he
admit
didn't-
to being the driver.
And so, to the extent that he said that the statement contained in his factual acknowledgement that he and fellow YSL associates, and I'd also point out that early on he made a very blatant, inconsistent statement that YSL is not a gang. And in this factual acknowledgement section,
All right, we're not going to use anything in the factual acknowledgement section of the 2015 plea.
no, in the 22 SC 183.
Okay, yeah, no. I mean, all of that is inconsistent with any of his trial testimony is fair game for you to tender for admission and for them to consider as substantive evidence against everybody. The issue we have that needs to get cleared up is that before I read this limiting instruction, I thought you were going to tender the guilty plea to this 22 SC case. And it turns out that you were talking about the 2015 case, which I understand you're saying we did part of that as, part of the 22 factual acknowledgments. So those factual acknowledgments in there are fine as well. When I say in there, I mean in this 22 case. But I'm going to have to clarify for the jury that what I told them about prior inconsistent statements
does not apply.
And that everything you just read from that guilty plea also needs to be disregarded.
So, Your Honor, as it relates to the court's instruction to the jury regarding the inconsistent statement not applying, we would only ask that the court specify that the court is speaking as to the factual basis that I asked the witness about in 15 SC 138994, particularly where he has testified and he pled in his best interest.
Okay. And you haven't tendered yet the 444Y. And so at the point in time when you tender that, then I'll say, okay, for this one, this is true.
I see what, yes.
Okay.
Yes.
All right. If anybody wants to suggest specific language, I'm willing to listen. Otherwise, I'm just going to kind of give it my best shot.
I would like.
And Your Honor, may I say one more thing?
Yeah.
Because number one, the court has previously instructed the jury that questions, and I understand the content of the question needs to be addressed. But given that the witness has testified that he pled guilty in his best interest, and given that he can also be cross-examined as to whether or not he was asserting these things, we don't believe that anything beyond a instruction regarding the factual basis for 15 SC 138994 not being considered a statement of the witness is required.
Okay.
I just respectfully don't think that goes far enough. You have a prosecutor who's saying it's just a blind plea. She leaves out everything about Alfred. She elicits, and I'm not saying that she could have anticipated this, but her questioning elicits that a non-testifying severed co-indictee pled guilty also. That is a total Confrontation Clause violation. It's the second time.
All right. And that's Zachary and.
Well, Mr. Zachary, I anticipate may testify.
Right.
I don't know. He hasn't yet, but it definitely includes Mr. Garlington, who the state has said will not be testifying. And then, just for you to know, you were not here, but the predecessor judge permitted, over objection, the state to do the same thing. They did it with a Mr. Winfrey, just like the court reporter's last name. He's not going to testify. No one believes he's going to testify. The state doesn't say he's going to testify. And they got out that he pled guilty. So they're aware of all this. And in fact, the state elicited in that case that the gentleman, Mr. Winfrey, pled guilty to avoid plea. It was vacated by the Supreme Court of Georgia.
Yeah, I remember you.
So, and
Didn't
then
he enter another one after the fact, though, anyway?
5 years later, Alfred plea and said I'm
Okay.
specifically innocent.
Yep.
I mean, it was a farce.
Right.
And
Okay.
and then the predecessor judge wouldn't even let me examine the witness. And Miss Love said that the witness I could call in my case in chief on direct. So the reason I'm bringing that up is this is not new.
Okay. What's your intention with regard to Mr. Garlington? Do you have any intention of calling him?
Your Honor, no. And Mr. Steele is absolutely correct in terms of the witness testifying about Mr. Garlington and Mr. Zachary and his doing that. There's nothing that indicates that the only reason he did that was because they pled guilty. So that is not, in other words, his statements that he gave to the jury about Mr. Garlington pleading guilty and all of that are not something that I asked him about or expected him to be talking about.
Right. Okay. But nonetheless, we have that now before the jury.
We would
So-
ask that the court tell the jury to strike, disregard, put out of their mind anything about the Mr. Garlington pleading guilty.
I'm just to say anyone other than the witness on the stand.
Okay. But Mr. Zachary is a witness.
I know that, but he hadn't been called yet, has he?
No.
So
no.
deal with it when he gets called.
Yes.
Yes, sir. Let's just say something.
Poised.
All right.
Judge, I fully adopt on behalf of Mr. Nichols, and I know I don't need to under the rule we're operating under, the motion for mistrial. I understand your ruling. I understand you're going to give an instruction, but I ask that as part of that instruction for an admonishment under 17-875, and I think that admonishment is mandatory, where counsel makes statements of prejudicial matters which are not in evidence. And I believe that this applies to this particular instance under these particular circumstances. So I'd asked the court to admonish counsel. Yes, in front of the jury, obviously, as part of the instruction.
All right. Give me a second to get signed into Lexis and take a look exactly at what the statute says. Do you have any suggested language? I'm sure you do. That would be appropriate for the court to give at us as an admonishment.
I haven't. We can come up with something.
All right. Well, let's endeavor to do that right now.
Permit the state to make a response.
You may. Go ahead.
Now, okay. Your Honor, given that 17-875 refers to statements of prejudicial matters, which are not in evidence, and the factual basis given or read by the prosecutor in the plea in the 15 SC case, while containing details that are not contained within the factual acknowledgments of 22 SC 183-572, it contains, it's about the same act, which in the factual acknowledgments for this case, the defendant says occurred. He admits and acknowledges that he, Demekion Garlington, and Quindarius Zachary committed a drive-by shooting at this residence, and that they committed the drive-by shooting on behalf of YSL and to increase the notoriety, reputation, and fear of YSL, and that he admitted and was convicted of aggravated assault, participation in criminal street gang activity, and among other charges for his participation in the drive-by shooting referenced in sections 3, 4, and 5. And given that this evidence will be properly before the jury, our position is that these statements, the questions that I asked, which contains the factual basis, the assertion about the factual basis in the 15 SC case, would not be a prejudicial matter. Though the factual basis is not in evidence, the fact of the shooting is not a prejudicial matter, which mandates a rebuke.
Okay. Well, the fact that a co-defendant who may not ultimately testify and who you do not believe will testify has pled guilty.
I don't disagree that that should go, but that was not something that I.
No, I know. I don't think that you intended to elicit that, but yes, I'm going to give a rebuke. Miss Love, I mean, that's just what it is sometimes to be the prosecutor in a case. Got to have a tough skin. Suggested language, Mr. Harvey or others?
Need for some smarter colleagues to give me some suggestions, which is everybody in these three tables.
And Your Honor, I'm still reading under the annotations of that particular statute regarding the rebuke.
We also presented this, by the way, as a guilty plea, not as an offered plea. And we read a factual basis from something that's not in evidence. It is so highly prejudicial that we all made a motion for mistrial. A rebuke is in order under 17875, and I think the court in front of the jury can say, and I hereby admonish the state for bringing up these matters that I have just told you to disregard. And the state should not do that again.
Your Honor, what the annotations say is what the law forbids is the introduction into a case by way of argument of facts, not only not in the record, but that are calculated to prejudice the accused. And
all right, Ms. Love, I'm going to give some sort of an admonishment. And I mean, sometimes you need to just, keep your powder dry and not argue every single thing to the nth degree. I've already said I'm giving it. So, I mean, I can grant a mistrial if you'd prefer.
Oh, no.
Okay, then maybe stop arguing at this point.
Yes, Your Honor.
Okay. Now, in terms of her having presented it as a guilty plea, an Alford plea is still a guilty plea, so I don't find there to be anything wrong with her having references in a guilty plea, but we already talked about the whole factual basis thing, so I won't rehash that, but okay. All right, and after I give the instructions, I'm going to ask y'all, I understand that the mistrial motions are preserved, but I am going to ask, since I haven't read out yet what I'm going to say, if y'all have any suggestions that you think would further elucidate, clarify, cure anything, I'm going to ask you for that. And if you have them, I would like for you to let me know that, and we can come up to the bench and consider any other further curative instructions, okay? All right. All right, let's get the jury back out. And I mean, I don't know that we need the witness in here for that, but
will the court prior to
go ahead?
Will the court prior to bringing in the jury, would the court be willing to read the
what
rebuke?
I'm going to say? Well, I don't know what the rebuke. I mean, it's probably going to be something to the effect of, after I explain to them what they're not to consider, I also admonish and rebuke you, Miss Love, to pay careful attention to how you ask questions and to what you put before the jury. Mr. Harvey wants more. What else? I'll consider it.
You should be banned from asking any more questions ever for the rest of the.
Well,
For the rest of my life.
reasonably speaking, though.
That may be going a little bit too far. But that's already been asked for, by the way. And that the court, in giving these instructions, intends to rebuke the state for asking those, for eliciting that improper testimony.
So, Your Honor, it wasn't improper testimony.
Okay.
It was the question.
Improper statements of the state. That's the whole point of a rebuke. That's the whole point.
And we would ask that the court just, if the court is going to read, that the court reads only what the court initially said.
I will say you should not have put that factual rendition before the jury as anything this witness admitted to. I'm listening.
At the time he pled guilty in 2017, because
I understand.
Your Honor.
Give me just a second. Sorry. Yes.
Let me request that the court consider including in its admonition the following language, if the court deems it to be appropriate. Somewhere in there, the presentation of that evidence that I've described was improper and was not in keeping with the law and the prosecutor's ethical obligations. Accordingly, the state is admonished for their behavior and is instructed to refrain from asking or presenting any improper questions or evidence moving forward.
All right. I'll do a little bit of it, but not all of it. What was that last sentence?
I like the first sentence.
I'm sure you do. Instructed to refrain from what?
Refrain from asking any improper questions or presenting improper evidence.
All right. Well, they're not presenting evidence, so.
And
right.
and should conduct themselves within their ethical obligations
All
and
right.
legality.
Thank you. I'm not going to do that.
All right, I got some more.
Got some more? All right. I think this is going to be enough. All right. Let's get the jury out.
Witness back first.
I mean, do y'all want the witness in here for this?
no, Your Honor.
Okay, let me ask you a question. Have you or somebody instructed, maybe even Mr. Wright, the witness to not talk about anybody else's plea to anything?
Can you let me go outside and do that?
Can Mr. Wright just do that? All right, let's get the jury out. Be in here? Okay.
Your Honor, we do request
all
that the
right.
witness is present.
Okay. Somebody let them know that. You can hurry. I mean, I've already said for the jury to come in, so thank you. All right, ladies and gentlemen, I've got some further instructions for you with regard to some of what you just heard. So I gave y'all an instruction that if this witness provided testimony that was inconsistent with a guilty plea admission, that you could accept that guilty plea admission as substantive evidence against any of these defendants. But then what we heard was that this witness pled guilty in 2017 to that being a part of that 2015 drive-by shooting. But and we heard kind of a factual basis that that the prosecutor in that guilty plea had read before the court, or somebody had read before the court, as a part of what Ms. Love was asking questions about, and she was, kind of reading it from a transcript. All right, here's the thing, is that guilty plea, as I think you heard this witness say, he entered that because he believed it to be in his best interest to do that. And this gets into a whole lot of kind of legal terminology and legal concepts, but there are a couple of different ways that somebody can say, yes, I'm pleading guilty to a crime. And one of them is called an Alford plea. It's just named after a case called Alford. But they're essentially saying, I am going to plead and accept that I'm guilty of this crime, but I am not saying that the facts that the state's putting forward are true. I am just saying I think it's in my best interest to go ahead and resolve it that way. So everything that you heard is, and that is totally legitimate to do that. And let me also say that Mr. Wright, who was representing this witness at the time, he let the court at that time in 2017 know, hey, this is an Alford plea. He's doing this because it's in his best interest, he believes, to do this. And Mr. Sledge was under no obligation after his attorney said that to, even if he got an opportunity to say anything else, to say, yeah, what my lawyer said, to add anything whatsoever to that. So I think there was a question about that, and he didn't, he didn't say anything else. He had no obligation to. He had no requirement to. He had no responsibility to. Okay. So basically what I told you about, you can take those facts and those admissions and consider it against him or anybody else in this trial. When it's an Alford plea, you cannot. So none of that I said was actually true about what you just heard about those 2017 guilty plea to the 2015 drive-by shooting. Okay. So let me think what else. Oh, and you also need to completely disregard that anybody other than this witness right here, Mr. Sledge, might have pled to anything that had to do with that drive-by shooting. All right. So just entirely erase that from your minds. And I also, at this point, am going to admonish and rebuke you, Miss Love, to pay careful attention to how you ask questions and to what you put before the jury. You should not have put that factual rendition before the jury as anything that this witness admitted to at the time of the 2027 guilty plea. And I'm going to instruct you to refrain from asking improper questions.
Yes, Your Honor. Thank you.
All right. Anything in addition that anybody needs to put before the court right now with regard to those curative instructions? All right. All right, go ahead, Ms. Love.